Hello students, welcome to XIV and embrace the XIV learning experience. Students, मैंने एक series start किया है with respect to the Companies Act, wherein I am going ahead and taking up the chapter-wise revision of the various provisions that are there under the various chapters of the Companies Act. I have already covered few parts of this particular series, around 6 you can say, और जहाँ पे कि मैंने हर एक chapter से जो important provisions है with respect to the various competitive law exams, I have discussed them. This is the 7th part of that particular series, wherein we'll be moving ahead with our further discussion of the various other chapters. In case if you have missed to watch any of those parts of this particular series, then in that case you can go to the description of this particular video, और description में आपको link मिल जाएगा उन सभी previous parts का of this particular series, and you can watch them. Let me tell you over here one more thing which is important is that with each of these parts, the videos, you are getting a test yourself PDF. Basically, there are questions in those PDFs which you can attempt, and to check your answers, you can download the answers which are available in the next part of the series. Apart from this, do remember to subscribe to the channel and press on the bell icon so that you can stay tuned and stay updated. And if any questions, queries or doubts are there, you can anytime connect with us through the email ID or the phone number which is displayed on the screen. Now moving ahead with our today's discussion, that is with respect to the chapter-wise revision of the Companies Act, we will be basically discussing chapter 13, which is basically laying down the provisions with respect to appointment and remuneration of the KMPs, that is the key managerial personnel. So who are these key managerial personnel is the first question we should be very clear of. ठीक है, तो क्या ये term जो है defined है Companies Act में? Yes, it is defined under section 2 clause 51. So इस particular section में define है KNP to include basically the CEO, the MD, the company secretary, the WTD, CFO and all, and they are basically considered to be the key managerial personnel with respect to the company. Now, if we talk about the appointment of the managing director, whole-time director or the manager, then you can see that section 196 is laying down the provisions with respect to that. But the first and foremost thing which the section mentions is कि company जो है managing director और manager को will not be going ahead and appointing at the same time. And why so? Why the company cannot basically go ahead and do the appointment of MD and manager at the same time? So in very simple, you can understand that if the MD and the managing director both are being appointed at the very same time, then the thin line of difference you can say that will be blurred, that distinction will be blurred you can say, and that can create a lot of confusion and overlapping in their roles. So that is why, since the roles and responsibilities to a large extent are same, in that particular context, the company can go ahead and appoint the MD or the manager and not both at the same time. If we talk about the tenure of the MD, WTD or the manager, then that is 5 years at a particular point of time. साथ ही साथ ये भी mention किया गया कि reappointment हो सकता है, but ये reappointment जो है, that cannot be made earlier than 1 year before the expiry of his term. What does that mean? Term क्या है यहाँ पे हमने देखा 5 years है, तो reappointment भी हो सकता है, but वो reappointment जो है 5 years का जो उसका टर्म है, ठीक है, उसमें से इट कैन नॉट बी मेड अर्लियर देन 1 ईयर. सो अर्लियर देन 1 ईयर क्या हो गया, मतलब 4th ईयर के पहले जो है रीअपॉइंटमेंट नहीं किया जा सकता है. सो इट कैन नॉट बी द सिचुएशन दैट आज 5 इयर्स के लिए नहीं करके डायरेक्टली ही विल बी अपॉइंटेड फॉर 10 इयर्स. नो, दैट विल नॉट बी डन. He will be appointed at a particular point of time only for 5 years. This person can be reappointed, but the reappointment can only be made in the 4th year. It cannot be made earlier than the 4th year because it mentions not earlier than 1 year before the expiry of his term, and expiry of the term is in the 5th year. Now there are certain disqualifications and all which are there with respect to the person being appointed in any of these positions. So the person should not be below 21 years or he must not have attained 70 years. ठीक है, अगर पर्सन ने 70 इयर्स ऑफ एज अटेन कर लिया है तो भी अपॉइंटमेंट हो सकता है, बट फॉर दैट देयर हैज टू बी अ स्पेशल रेजोल्यूशन दैट विल बी पास्ड, और एक स्टेटमेंट होगा इंडिकेटिंग द जस्टिफिकेशन एंड ऑल विथ रिस्पेक्ट टू सच अपॉइंटमेंट. इन केस स्पेशल रेजोल्यूशन जो है नहीं पास किया गया है, बट जो वोट कास्ट किया गया इन फेवर of that particular motion, that is exceeding the votes cast against the motion. तो उस केस में जो है अगर सेंट्रल गवर्नमेंट सेटिस्फाइड है based on the application which will be given by the board, the appointment can be made ahead if it is beneficial with respect to the company. अगर वो पर्सन जो है अनडिस्चार्ज इंसॉल्वेंट या एडजर्ज्ड इंसॉल्वेंट है, सस्पेंड नहीं किया है पेमेंट टू क्रेडिटर्स और हैज मेड composition with them, either of these he has not actually done, or he has not been convicted for any offense and sentenced for more than 6 months. Only under these circumstances the person can be appointed in those respective positions. Now if we talk about the various aspects related to appointment, वहां पे आप देख सकते हो जो भी उनका terms and conditions होगा appointment का या remuneration का भी, that has to be approved by the board. Approved by the board is important, but at the same time the shareholders also require to approve that, and they will be doing that by a resolution which will be passed at the next general meeting. So terms and conditions, remuneration, appointment, everything has to be approved by the board and at the same time will be subjected to approval by the shareholders. अगर कोई भी appointment जो है that is at variance with respect to the conditions that have been specified under schedule 5 part 1, then in that case central government's approval is also needed. Section 197, it is talking about what? The overall managerial remuneration that will be paid and remuneration in case of absence or inadequacy of profits. So in case of profits, what will be the remuneration? And if there is no profit or absence of profit, in that case, what will be the remuneration is what this particular section is talking about. So public company पे ये provisions applicable है and public company will be going ahead और जो total managerial remuneration वो pay करेंगे in financial year, that should not exceed 11% of the net profit for that particular financial year. Now the company can go ahead and in the general meeting can authorize the payment of remuneration जो कि exceed करेगा 11% of the net profit. In case अगर कंपनी ने कोई डिफॉल्ट किया है पेमेंट ऑफ ड्यूज एंड ऑल में, उस केस में उस पर्टिकुलर बैंक का, पब्लिक फाइनेंशियल इंस्टीट्यूशंस एंड ऑल का प्रायर अप्रूवल भी ऑब्टेन करना है before it is going ahead and obtaining the approval in the general meeting. Then remuneration जो भी payable होगा MD, WTD, manager, ये सबको that has been laid down the provisions with respect to that. So here you can basically see that for the managing director, whole time director or the manager, say if there is only one, in that particular case they will be getting maximum 5% of the net profit. If say there are more than one, in that case they will be getting 10% of the net profit. अब ये जो other directors होंगे other than the MD, WTD or manager, in case there is no MD, WTD, manager, तो उस केस में जो other directors हैं उनको 3% मिलेगा of the net profit. और अगर there are MD, WTD or the manager, then in that case the other directors they will be getting 1% of the net profit. Now the overall maximum remuneration in case of loss or inadequate profit, that has to be as per schedule 5. जो भी remuneration payable होगा to the directors including the WTD, MD और manager, that has to be determined either by the articles of association या कह लो resolution जो होगा उसके basis पे, या फिर अगर आर्टिकल्स में ऐसा प्रोवाइडेड है देन बाय वे ऑफ स्पेशल रेजोल्यूशन इन द जनरल मीटिंग एक्सेट्रा. ठीक है, दिस रेम्यूनरेशन दैट विल बी इंक्लूसिव ऑफ व्हाट? इंक्लूसिव ऑफ रेम्यूनरेशन जो भी पेएबल है फॉर द सर्विसेज रेंडर्ड बाय हिम इन एनी अदर कैपेसिटी, बट दैट विल नॉट बी इंक्लूडिंग व्हाट एवर सर्विसेज ही इज रेंडरिंग एज अ प्रोफेशनल एंड ही इज हैविंग द रिक्विजिट क्वालिफिकेशन एंड ऑल, देन इट विल नॉट बी कंसिडर्ड टू बी अ पार्ट ऑफ द remuneration. Then sitting fees to the directors for the services rendered, then sitting fees that will not be exceeding 1 lakh per meeting. Then remuneration that can be paid in any of these ways. It could be as monthly, it could be as a specified percentage of net profit, or it could be partly by these ways which have been mentioned above. Now next, if we talk about chapter 14, inspection, inquiry and investigation, that is there, the provisions have been provided with respect to this. Then section 206 is basically talking about the powers which are there with the registrar for going ahead and calling for information, inspecting the books and conducting inquiries. Okay, so in that particular case the company will be going ahead and company will be furnishing all those informations, documents, explanations जो भी registrar will be calling ahead and seeking from the company, or additional informations, details, if it is necessary the registrar can go ahead and also ask for those, but that will be done by the registrar after reviewing the documents or the information that has been received by it. And whatever things are required to be furnished to the registrar, that has to be done within a reasonable time frame, जो कि notice में specified होगा या फिर कोई extension and all है, which is being granted by the registrar. So taking into consideration that एक reasonable time frame में that has to be basically provided to the registrar. जो भी officers हैं company के, they are responsible for going ahead and complying with this particular obligation of furnishing all the details to the registrar. जो भी former officers हैं, those who have actually worked during the relevant period, they may also be required to provide information or explanations अगर registrar is requesting for the same, that he'll be doing by way of notice, you can say. Now registrar will be demanding further books, papers, explanations from the company through written notice, and it can be basically done by the registrar under certain circumstances. So what are those circumstances? Say if there is lack of response from the company, जो भी time frame दिया गया है, specify किया गया था notice में, if there is lack of response from the company within that time frame, if there is inadequate information etc. which is being provided upon documented examination and all, and if the registrar is of the very opinion that there is unsatisfactory state of affairs within the company, okay, and that is not disclosing the required information adequately, then also it can go ahead and do so. And before issuing any notice, the registrar must document the reasons in writing. So the reasons have to be there documented in writing. Then registrar can initiate an inquiry after it is satisfied that there are certain conditions that are prevalent in the company, say fraudulent or unlawful activities are being taken ahead in the company, within the company, you can say कोई भी non compliance है with the provisions of the act, unaddressed grievances हैं investors के and all, then in that particular case also it can go ahead and initiate an inquiry. Central government can also direct an inquiry if the circumstances warrant so. Now there will be inspection and inquiry that will be conducted. Okay, so the provision lays down that in that particular scenario, the director, officer and employees, they will be providing their full cooperation and support to the registrar or the inspector who will be going ahead and doing the inspection, inquiry, etc. They will be providing certain things to them like the books of accounts, papers, etc. which will be requested. Offer necessary statements, informations, explanations again as they might be required by the inspector or the registrar. So ये सारी चीजें उनको provide करनी है, assist करेंगे all aspects जो भी related to inspection है उसमें they will be cooperating, providing the much needed help. Now the powers of the registrar or inspector during the inspection will be that they can go ahead and make copies of the books of accounts and other documents. They can place identification marks and all with respect to the books and all which they have basically inspected and all, so that it can signify that inspection has taken place and all. They will be having the powers similar to the civil court and they can go ahead and exercise those. So these are the powers basically which the registrar or inspector will be having with respect to the inspection and inquiry which they will be conducting. Now report on inspection being made. Section 208 is basically talking that once the inspection is being done with respect to the company's books of accounts or inquiry is basically done into other books and papers, then in that particular case the registrar या जो inspector है they will be providing a written report और ये report किसको submit होगा? Central government को होगा. ये जो report central government को submit होगा इसमें relevant documents and all if it is required it will also be included, and the report may also go ahead and it can suggest or recommend that further investigation should be taking place with respect to the company's affairs, and उसके लिए reasons भी देने होंगे कि क्यों वो particular further investigation होना चाहिए. Search and seizure is there, the provisions with respect to that under section 209, जहाँ पे कि अगर inspector या registrar suspect करता है कि जो company का books and papers है that might be tampered and all, then in that case court order can be obtained by them for taking action as required. फिर they can go ahead enter into the premises and all so that they can go ahead and conduct the search. वो लोग seize भी कर सकते हैं जो भी books and papers हैं with respect to the company. Once they are going ahead and seizing any item of the company, then within a period of 180 days they have to go ahead and return that. Although यहाँ पे provision ये भी है कि they are having an option for an additional 180 days. So 180 days के अंदर में they have to return those items which they have seized, but they can get an additional 180 days for going ahead and keeping them with themselves. once they are going ahead and returning those seized items, they may basically take copies or extracts of them, place identification marks, etc. on those. Okay, so that can be basically done by them in the process of search and seizure. Then investigation into the affairs of the company. So central government for that particular purpose will be appointing one or more inspectors who will be investigating the affairs of the company, and they will also be reporting to the central government. So when this particular appointment can be made by the central government, it can be on the receipt of report from the registrar or inspector, on intimation by a special resolution by the company that the affairs of the company and all needs to be investigated if it is in the public interest. So all these grounds, the central government can go ahead and appoint one or more inspectors to go ahead and investigate the affairs of the company. Then there is SFIO, which will be established. So section 211 is providing that establishment of serious fraud investigation office. So basically SFIO is established to go ahead and investigate the corporate frauds and all which are there, and it is one of the multidisciplinary organizations which are consisting of experts from diverse fields. Okay, so with respect to the SFIO, the central government will be going ahead and doing the establishment, okay, so that it can investigate into the frauds and all related to the companies. It is being led by the director, okay, and he should not be below the rank of a joint secretary. Okay, obviously he will be having, or he should possess the knowledge and experience in the corporate affairs matters. SFIO में जो है experts होंगे, various fields से होंगे. Central government will be going ahead and doing the appointment, and those various fields could be banking, corporate affairs, taxation. So you can see the various fields are there from where the other experts of the SFIO, their appointment can be made. Okay, because it has to be a multidisciplinary organization which can go ahead and take care of all the frauds related to the companies. Now, investigation into the affairs by the SFIO. So, SFIO can go ahead and investigate into the affairs of the company. So, if the central government is assigning the investigation with respect to a company to the SFIO, that it can go ahead and do based on the receipt of report, you can say, which the registrar or inspector will be giving, या फिर intimation होगा by special resolution where the company requests that investigation should be there into the affairs. Public interest में है, then, and if say there is any request by any department of the central or the state government. So उस particular scenario में SFIO can go ahead and investigate into the affairs of the company. Now upon receiving an order from the central government, the director of SFIO will be going ahead and designating required number of inspectors and all who will be taking ahead the entire investigation process and all. So in that particular way, they will be conducting the investigation and all with respect to the affairs of the company. Okay. And these investigating officers who will be appointed, they will be having the powers of the inspector, which are detailed under section 217, so that they can go ahead and conduct the investigation. So with this, we come to an end of our discussion of this particular part of the series. Do remember to subscribe to the channel and press on the bell icon so that you can stay tuned and stay updated and make your preparations 50% faster with us at XIII.